So, the General Data Protection Regulation. I'm sure you might have all heard about it. GDPR, it is not something new. It is something that actually is applicable since 2018. And probably the main way in which you have been interacting with GDPR is the cookies that you have to accept on every single website that you visit. We're not going to talk about that today, don't worry, although there will be a lot to say about the GDPR cookies. But why are we here, and what we are doing here is that we want to present a new report. We've been working on this report now for the last few months, and so today we will delve a bit into it and try to discern what are the main findings of this report and why do we believe it's a relevant publication that should be also taken in consideration by the European Data Protection Board and all of the other data protection authorities that are looking at how to apply GDPR. But before we start, I will first maybe let my co-panelists introduce themselves, and then I give a bit of intro and context, and then we get started. All right, you want to go first, Erwin?
Sure. So, pleasure to be here again on stage. So my name is Erwin. I'm the Director of Research and Strategy here at Blockchain for Europe.
Thank you, Erwin. And Jörn?
Thanks very much for inviting me. It's an honor to be invited here, also to have had the chance to write this report. I have a background in law and computer science, and I did my late thesis on a topic between blockchain and GDPR. So I'm really happy to present here.
Great, thank you so much. So a bit of context, a bit of intro. When did this all start? Why are we here today? If you don't know, what happened this year in 2025 is that, first, let's take a step back. 2018, as we said, is when the GDPR started being applicable. And already back then, however, there was a very relevant opinion that was published by the CNIL, so the French Data Protection Authority, correct?
Yes.
Correct, thank you. That opinion was already pretty influential, pretty important in highlighting some concerns in the way that the definitions of personal data, for example, within the GDPR context, could not really make sense, for example, when looking at the blockchain context. And so that is why the CNIL opinion was very interesting, very influential back then. And we, as an industry, were all hoping that this opinion will be taken in consideration by the European Data Protection Board. The European Data Protection Board, for those that do not know, is basically a grouping of all the European data protection authorities of the European member states. So, the European Data Protection Board has been looking at this question for some time, for quite some years. We were hoping that, of course, their understanding of personal data, of the roles that exist within the GDPR context of controllers and processors of data, we're going to go into these technical details later on. We were really hoping that the EDPB would understand the way the GDPR provisions and rules can be effectively applied, especially to public blockchains. However, in April this year, we also a draft guidelines published by the European Data Protection Board, draft guidelines number 2/2025, that were basically trying to clarify the application and applicability of GDPR rules to blockchains. And when looking at these draft guidelines, well, I think whoever saw these draft guidelines probably shared the concerns, the surprise, the questions that everybody in this industry somehow had looking at some of the language that was introduced by the European Data Protection Board, especially, for example, on what should happen in the case of a data deletion request, right? There was a few very potentially problematic messages that were basically outlined in these draft guidelines. I keep saying draft because that's important to highlight. These are draft guidelines, meaning that they were somehow open for public consultation, right? So the EDPB put out this draft and then asked stakeholders to respond, to provide their feedback, to provide their input. And the idea would be that these guidelines then from a draft will be completed, will be finalized, and will be made official by the end of this year. So in that process, we actually started working on these questions, trying to understand how can we help the EDPB and support their understanding of the applicability of GDPR rules to public blockchains, for example. So we got together with our members, which is the way that we deal generally with public consultations, is to respond to this public consultation together with our members, pooling the technical expertise that exists within our membership, and working with the experts that are actually members of our advisory council. By the way, you can see all of this information on our website, so if you're curious to see who's a member of Blockchain for Europe or who's a member of the advisory council of Blockchain for Europe, you can obviously find all of that on the website. So, after this process, getting together and putting together this response to the public consultation on the guidelines, then we decided that, well, this is probably not enough. We want to do more. We want to understand better this question of how can GDPR be applied to public blockchains, or is there a way in which blockchain actors can somehow comply with the objectives of the GDPR in a way that is actually technically and feasible for these actors. So that is why we then contacted Jörn, and we decided to work together to start analyzing the GDPR in depth, every provision really of this massive regulation, to try and understand how should these provisions be read in a way that doesn't precludes the use, for example, of certain technologies, or it doesn't make it impossible for actors in the blockchain and Web3 space to comply with these rules. So I think that's basically everything for my quick introduction and context. And because now, once we've gotten together with Jörn, once Erwin also joined our team, together also with the input, a lot of input and efforts by our members, we got today to present, and we're here today to present to all of you our GDPR report. So I think that's maybe a good timing for me to stop, for the slides to come up, and for Jörn to take over and talk a bit about our GDPR report.
Thank you very much. So the role of EDPB guidelines is also important to know. They are not the law. They are, if you go to a court, they do not count as a source of the law. But of course they provide guidance to data processors, controllers, and to other data protection authorities. So they are nevertheless important, but we see some kind of deviation between the law, the decisions of the European Court of Justice, and the opinions of data protection authorities, particularly in the domain of the definition of personal data. And regarding the CNIL, I think the CNIL in 2018 did two things quite right. They looked at controller, who is a controller in the context of public permissionless blockchains, and also they saw the positive potential of decentralized technologies like blockchain, and they didn't just try to see only the risk. And in this regard, I have to say that the EDPB did not follow this balanced approach. So let's see what were the main points. Does it work? Yeah. So fundamental issues. We have an issue with the definition of personal data. It extends beyond the text of the GDPR and the jurisprudence of the Court of Justice in the EU. So why is this so? Because every kind of possible identifiability is taken into account, and we recently had a decision by the European Court of Justice, which again emphasized the position of the court that it has to be limited. In this case, it was pseudonymized data that was not identifiable by the controller, but by the source of the data. And the European Court of Justice said, this is not personal data for that controller that cannot identify the data with natural persons. And Why is this important? It is important because we have all kind of verification artifacts. We have perfectly hiding commitments. We have zero knowledge proofs. And of course, you can relate them to the original data that they are proving. Otherwise, they wouldn't make any sense. But you cannot retrieve any kind of information about what they prove from the verification artifacts. And this is a main burden to privacy-preserving technology in an open context. Because if you cannot put them openly out, then a lot of decentralized privacy-preserving approaches wouldn't work. So this is, I think, a very important point. Another point is controller and processor discussion. And as I said, the CNIL got it better, got it more right than the EDPB. The EDPB does not directly contradict the CNIL in this point, but kind of doesn't come to the point that, well, of course, there are cases where even in a public permissionless blockchain, nodes can be considered controllers, but in the normal use case, it is not the case. And the EDPB could have been clearer in stating that. And the most important point, I think, is the missing of the balance. We have definitive benefits and risk mitigation properties of decentralized systems by getting rid of intermediaries. And this benefit is not taken into account. And it should be balanced with some risks that blockchain technology can have to a data subject, and also it should be the free choice of data subjects to say which kind of risks they want to get into and which kind of risks they want to avoid. And besides those fundamental issues, the clicker, I was missing an extensive discussion of legal basis. So under GDPR, every processing of personal data needs to have a justification, a legal basis. The most commonly known legal basis is consent, but there's much more than consent. So there can be contract. For example, if you buy some tokens, cryptocurrency or what crypto asset, then you have a contract. And the contract is a basis for doing this transaction. And this is a perfectly legal justification, a legal basis for writing this data on chain. And also consent was not sufficiently considered. Then we have the eIDAS regime. Some years ago, we had a revision of eIDAS introducing electronic ledgers and qualified electronic ledgers. And qualified electronic ledgers are kind of private permissioned or public permission or private permission blockchains. And in the implementing act, it clearly states that the integrity means immutability, so that the qualified trust service provider must not delete anything. And of course, this is a perfectly legal basis and would have needed to be considered. And also in the financial and crypto asset regulations, there are some duties or requirements. For example, in MiCA there's a requirement, if you want to trade coins, they must not be privacy coins unless you can show the transaction history. So there are legal bases there that have to be considered. Maybe this last one might be resolved because the EDPB announced a report on that as well. So we will see how they will deal with it. Hopefully, we will see. Then, next slide, please. And then we have publication transfer and proportionality. When you have a public permissionless blockchain, of course you have no control where the nodes are, where the information is going. So you could say, well, this is a third country data transfer. Meaning a third country data transfer means a country where there is no appropriate protection of personal data. And of course, the GDPR has strict rules about that. But of course, this problem is not new. Whenever you publish anything in the internet, it can be transferred to all over the world, all over the universe. So you have no control anymore if you publish things on the internet. And already in 2003, the European Court of Justice saw it and said in Linquist, we do not want to apply the strict rules of third country data transfer on publications, because otherwise publications in the internet would be very difficult. And we don't want that to protect freedom of speech. And they even said it does not matter where the publishing server is. So even if you first transfer to a node in a third country and then the node publishes it, and of course it's transferred there to be published, that does not even make this Chapter 5 applicable where you have the third country data transfers. And of course, you can discuss, is it still applicable, etc. You can do a lot of discussions, but the EDPB did not even discuss it. And another point we had, there is a point where in the draft guidelines where the EDPB says, well, there might be a situation where you have to delete an entire blockchain because there's one entry on the blockchain that is infringing data subject rights. And here we are missing the principle of proportionality because, of course, there is a right of a data subject and there might be some reason why a certain transaction or block infringes on some data subject right. But you have so many other data subjects that would have an issue with deleting the information. So you can't just prioritize the right of one person against the right of many others, but you have to balance them and to apply the principle of proportionality. Does this mean that the person has no possibility to act, to sue? Of course not. You can still claim damages from those who should not have put that information on a blockchain. And so you're not without rights, but you have to balance the rights of the different data subjects. Please, next slide. And maybe the most disturbing thing is that we miss any kind of outlook. Since 2018, of course, the ecosystem, the technology has quite advanced. Now we have new blockchain architecture. We have privacy-preserving designs, and we separate the different layers. And this, of course, is all going towards what the GDPR demands. And the EB did not consider it. And the EB did not say, well, this is a good direction. You should go this way, rather not that way. You should have this choice of technology. They did not differentiate. They did not take into account the developments, the innovation, the privacy-preserving innovation. That's what they should support and go for. And so I was personally very disappointed with this draft. So were most of the community, particularly the privacy-minded community, blockchain community.
Thank you so much, Jörn, and I think that was a very good, at least initial overview, and of course we invite everybody, we go back to the next slide so that you all get the QR code again. Yes, so you can still all access our report. So thanks for giving our audience a bit of an overview of the main issues, right? We talked about the definition of personal data, the roles of controllers and processors of data, and the way that these fits or not in the context of public permissionless blockchains. And indeed, I think also very important at the end, what is the future outlook, right? What the very important chance that was missed on talking about privacy-preserving technologies and other, privacy by design infrastructures. So thanks so much, Jörn. And now we'll turn to Erwin, who's going to be maybe having a bit of a exchange on some of the more technical aspects.
I'd like to start with the outlook. I mean, I think this is probably one of the most interesting parts, at least for me, on where we are. Because if you look at the way that the industry has developed, we've gone from kind of like monolithic layer ones to modular architecture, layer twos, subnets. There's different roll-up architectures, and if you take like just the EVM environment, for example, as a very large sample, because it's quite large. If you look at things like peer data availability sampling, if you look at threshold encryption, if you look at fully partially homomorphic encryption, if you look at different ZK substrates, if you look at all of these developments where you're able to develop the infrastructure from the ground up with this privacy by design, none of this was reflected in any of what the EDPB actually put out in their guidelines. I mean, they were assuming the development of the industry was kind of at a stasis in 2017, and they were like retroactively applying their views to a point in time that no longer exists. And even with the way that validators, validator proposers, builders, attesters, all these things have become unbundled, and this also has an impact on like the way that data transfer, the relationships between data subjects and controllers effectively operate on chain, and also what kind of data, the size of that data in terms of the packets, the bytes, and the cadence of that compression is put off chain, and this is material. This is not non-consequential. And one thing I would also like to stress is that in order for there to be perhaps some continuity in terms of how industry and policymakers are viewing these things, I think we need to start from this initial, at least for me, this is the initial predicate. When you look at those guidelines, it's not that they're negating things like ZKs. In fact, they do touch on them, and they understand that these technical artifacts exist. The problem is that they view them as kind of like an ancillary thing, as like an add-on to a centralized architecture. So it's assuming a very like top-down approach where these technical artifacts may or may not be useful, and we should consider them, but by no means we should have them wholesale as the thing. Whereas if you take like a really hardcore industry, like a privacy preserving approach, you view this as this technology should be built from the ground up as an infrastructure itself. And so I think in the mindset of the regulatory community, that's something that needs to also be taken into account. And the third thing I would like to add is that privacy preserving technology has a commercially viable purpose. Not only does it compress data, but that also compresses costs. And it allows data to be transferred more seamlessly. And I mean, we recently saw it at DevConnect with the launch of Ethereum's PSC team. We're talking about OpenAC, which is really interesting because it allows for this. I think it was confirmation times using ZKs of like 0.129 seconds or something, and it allows this like full anonymity for legally determined predicates to be set without kind of revealing this. And so we're talking about applications of this technology in privacy pools and other infrastructure layers that have huge commercial viability in structured finance, in healthcare, in supply chains. And so it's not just talking about privacy for its own sake, but it's the commercial viability of privacy that's also important.
Thank you, Erwin. I don't know, Jörn, if you want to add anything else or respond to anything that Erwin mentioned.
Well, of course, that's basically the outlook we have, and that should be considered, and that is advancing privacy. It's not against privacy. So maybe when you talk about AI and GDPR, you talk about certain technologies that pose a risk to privacy that might endanger the privacy of data subjects. But here we are talking about better privacy, and GDPR is not there to prevent better privacy. And so this is, I guess, the main point. But I'm very happy that we see some kind of movement happening now. We see how the industry reacted. We see that the Commission has made a proposal to change the definition of personal data into a relative definition. As the Court of Justice already did, but the Commission goes a little bit further. There might be some discussions necessary, some refinements, but the important point is that the verification artifacts should be outside because they actually split the proof from the data. And if the GDPR does not follow suit, you don't have the advantage of protecting the personal data. And I'm confident that we will get somewhere, and of course the battle is not over, but it has just begun. But when I started writing the report, I was much more pessimistic than I'm today.
Well, that sounds like a positive way to end a report. Yeah.
Just to pick up on the one other thing you said, because you're talking about the separation of the proof from the data. I mean, that's also really important because ultimately, when you're the big issue is that if there's certain things that are left in the outstanding hash, and if you borrow where this kind of approach came from, the Schleswig-Holstein interpretation of this, those things that are essentially amounting to alphanumeric strings end up being kind of roped into this collective definition of personal data when they are not. And if there is a way to sufficiently scramble that using some means of obfuscation or selective disclosure, it should be proportional to your earlier point when you were explaining kind of the contours of the report. That proportionality should then be sufficient to decouple the artifact from what is kind of substantively considered personal data, rather than just groping them all in wholesale. And then because we will always then run the risk of no matter what we do, no matter how sufficiently we hash or obfuscate or scramble or what technique we use, you're never going to satisfy the requirement, right? That's the problem. Like it's a litmus test that is set so unrealistically high so as to be technically unachievable.
Exactly. So even if there is a solely theoretical possibility to decrypt the data in the future, it's sufficient for data protection authorities to call it personal data. And regarding hashes are a one-way street. And they can be used to as identifiers, as pointers to connect data, and they have been used in such a way. And of course, this is problematic. So hashes have no blank green light, but they can be used in a completely, perfectly hiding way as well. And then, of course, they should not be regarded as personal data.
All right, gentlemen, I think we have to get to a close. I don't know if there is any question from the audience, considering it was obviously a very technical conversation. If someone has a technical question or anything else, we can take it really quick.
There's a question here from the audience, maybe Jörn for you. A cryptocurrency address can be from an exchange that could be identified by law enforcement. Is that address personal identifiable information under GDPR?
Well, if you take the decision on IP addresses, the prior decision, you might say yes, because there is a legal way to identify the address. Only if there's a legal way, but then you have to look for the justifications, because it's actually a legal requirement for an exchange to have this possibility. So you could not really tell them, well, you must not put this, but if you don't put it, you are not allowed to trade this cryptocurrency. So here I see rather the discussion of the justification, and that there is a justification, than saying, well, this is not personal data. But of course, this is in the flow, and if you apply the EDPS versus SRB case is a recent case, and if you apply the definition that the Commission has set forward, it might no longer be personal data. So we need to discuss this, but either it is personal data and then it is justified, or it is not, and then you don't need a justification.
All right, thank you so much. We do have to get to a close, but again, I will invite everyone to go to our website and read our report. It's quite detailed, quite comprehensive, so whoever has questions afterwards will be happy to discuss it. Again, I think to conclude, one thing that Jörn said, this is really meant to increase and help and preserve privacy, right? The whole point is that blockchain technology can help us achieve that, can help us achieve the GDPR objectives. They're not in contrast. We just need to find a better way to interpret the GDPR rules in a way that doesn't mean that we cannot be using public permissionless blockchains, for example. So, thanks again. Thanks, Jörn. Thanks, Erwin, for the conversation. Thanks, everyone, for listening to us and for reading our report. And please join me in a big round of applause. Thank you.
Thank you.
Thank you.